thank you very much for taking the time to meet us.
You are quite welcome. I'm going to adjust that or it's going to make me crazy. Okay.
Thank you. All right, so let's start out with some simple stuff. What's the mission of the Commission on Judicial Conduct?
Well, it's created under a section of the state constitution, and what it's directed to do is enforce the Code of Judicial Conduct. Those are the ethics rules for state-level judges, and those rules are promulgated by the state Supreme Court. They're based on the model rules, the Model Code of Judicial Conduct that was created by the ABA, actually, the American Bar Association.
Mm-hmm.
And they are a version of the Code of Judicial Conduct is adopted in all 50 states, one version or another, usually pretty close to the model. And the model has existed, the original model has existed since I think 1925.
Okay. All right. You did give me some background on it. Now, what's the makeup of the Commission? As far as
who's the membership?
Yes, who makes up the Commission?
There are actually 5 separate appointing entities. So the ideals of the code are to ensure the independence, integrity, and competence of the judiciary. Those are the ideals behind the code. And independence is an important element. So sort of in parallel to that, the entity that enforces the code needs to have independence, and structurally part of what assists in independence is that there are these separate appointing entities. So the majority of the appointees to the Commission are public members. By that I mean non-lawyer, non-judge members. So there are 6, there's 11 total members. And the majority are appointed by the Office of the Governor. They're in 4-year staggered terms, so often the appointees will be appointed by different governors just through the passage of time. And so you've got those appointees. I've worked with 3 governors making appointments to this commission, and they have all tended to try to make appointments with a lot of diversity, and by that I mean gender, race, jurisdiction, place in the state, rural, urban, that kind of thing, and then different backgrounds. There have been business people, journalists, a former Speaker of the House, community activists, just a range of different sorts of folk that governors have tended to appoint. So that's 6 of them. There's 11 total. There are 2 lawyer members, and they're appointed by the Bar Board of Governors. They appear to me also to strive for diversity within their bar appointees. So as an example, we have had partners of major law firms. We have a woman who is basically a public defender for sexually violent predators. We have had, don't have one now, but we've had people who worked as prosecutors, people who've done business law, people who are sole practitioners, just a really range. And again, urban and rural, different geographic type folk. Then there are 3 judge members on the commission. There is one from the Court of Appeals, and that person is appointed by the presiding judge of the Court of Appeals. There is a member who is from the Superior Court Judge Association, and they are voted on by the Superior Court Judge Association. There's one who is from a court of limited jurisdiction, and again, they're voted in by their judge association. And so there are 3 judge members. Now, for each of these categories of members that I talked about, every single one of them has an alternate who is appointed by the same appointing authority. And the purpose of an alternate is so that if the regular member is recused from a case or physically unavailable, the alternate steps in and votes in their stead. So, for example, all judges in the state draw complaints just by the nature of their work. And if a judge on the commission is the subject of a complaint, obviously they're not going to sit on that complaint. In fact, they don't even know it exists. We have a recusal list, and if somebody has a judge on their recusal list, it's themselves, or they know them and work with them on the same bench, or they're a friend or something like that, that member doesn't even know about the cases being here.
Interesting.
And the alternates also fully participate, but for voting if their regular member is there. So if a person's not recused and they're an alternate, they'll get all the materials, they will participate in the discussion, they may have lots to contribute. Then when it comes down to the vote, they don't get to vote, but they're fully informed so that they're familiar with the issues, they're familiar with the discussion points, they can avail themselves of information they get as cases are discussed. So for example, there's a case involving a certain kind of calendar, say an anti-harassment calendar. The judges who sit on those calendars, or lawyers who represent people on those calendars, can kind of add the information that you got to realize this is a calendar, it's half a day, there are 50 cases, the judge has to give everybody their time, so they're not able to let everybody talk for as long as they want to talk. It's part of their job to control that calendar and make sure that everybody gets heard with the amount of time available.
Okay. Now, is the commission is this a private corporation that's kind of like a contractor, or is it actually part of the government?
Yes, it is created under the state constitution, and it is defined as an independent agency of the judicial branch.
And is the commission a venue for redress of grievances?
Not really, no.
No?
I would say, and let me explain that a little bit. People don't go to court generally unless there's something that they really feel passionately about. There's something that's important to them. They've been charged with a crime, they're a victim of a crime, they've got an issue that affects their livelihood, their custody, their speeding ticket. It's, whatever they come to court for, it's important to people. And if they don't prevail, they often feel that justice wasn't done. But you're not going to get a dispute in the adversary system unless both sides really think they're right. Somebody's going to win, somebody's going to lose. And so people do sometimes complain to the commission with a mistaken impression that the commission is empowered to fix their situation. Either reverse the ruling, or get the judge off the case, or get the judge off the bench. And that's not really what we do. We enforce the Code of Judicial Conduct. So it's a parallel track to whatever happened in their case. We don't directly affect that case. We don't have the power to. However, if a judge violated the code in a significant enough way, or often enough, this commission is empowered to make recommendations to the state Supreme Court that that judge be suspended from the bench or removed from the bench. And sometimes, because we can also resolve our cases by agreement, judges resign in connection with a case.
All right, I was going to ask what actions can be taken against an offending judge, but...
Well, there's more.
Okay.
So, every complaint that comes to the commission gets investigated, all of them. And every complaint gets brought to the voting membership that I described to you. The staff doesn't make any decisions. We simply bring the materials to the membership and also investigate the allegations and bring the law that's to bear to the membership so that they're ready for discussion. And part of our job too is all the staff that work on complaints are attorneys. So part of our job is to try and put the public members, the non-attorney members, on more of an even keel with the lawyers and judges that they're interacting with, to make sure as much as we can that they understand the concepts and the issues that the legal issues that underlie the complaint. There are 3 levels of sanction that can be imposed by the commission if it is shown that a judge has violated the code. A judge can agree that they violated the code and stipulate, or they can have a hearing, a fact-finding hearing. It's very like a trial, where the burden on the commission is to prove by clear, cogent, and convincing evidence that the code was violated. And then the panel decides what to do about that. The 3 levels of sanction are admonishment, which is a written advisory indication that the code may have been violated, that the person should not do that again. It is the least severe sanction available to the commission, and it doesn't require that they personally appear before the commission to receive the admonishment. The next higher level is a reprimand, which finds that the code was violated, that it requires the person to come before the commission to receive the reprimand, and requires that some remedial action be taken. There's also censure, which is the most severe. It finds that the code was violated in a manner that undermines public confidence in the integrity of and independence of the judiciary, and it requires that the judicial officer appear before the commission. It requires that remedial measures be taken, and the commission may, but doesn't have to, with a censure, recommend to the state Supreme Court that that judicial officer be suspended for a period of time, with or without pay, or removed. And that if that recommendation is made, then the Supreme Court reviews that de novo and decides what to do.
Okay. Now, while the secrecy, justice is supposed to be administered openly in Washington State. So why the secrecy of these investigations?
Well, there's both secrecy and openness in the commission's structure. So the secrecy is in the investigation and dismiss complaints. Couple very practical reasons for the confidentiality of pending complaints. One is judges are pretty powerful people. We depend on interviews with people who interact with them in large part to get our information. So court staff that's very subject to the judges, and get fired. People who have cases pending before that judge, who have a lot at stake and don't want to anger the judge for either giving us information or having it known that they gave information or filing a complaint. Lawyers who make their livelihood by appearing before that bench may have incredibly valuable information but don't want to say it if they know that the judge is going to hear about it and they're concerned about retribution. It would be extremely difficult to do investigations that would yield any information at all if we exposed our sources constantly to the fact that there was an investigation pending. Kind of like a journalist protects their sources in order that they don't suffer retaliation and so that people are willing to talk to them. The flip side of that is, I told you we investigate everything we get. And the vast majority, and this is true in all 50 states have an equivalent commission, and the rate of dismissal of complaints hovers around 90%. A typical complaint, it goes like this. Somebody went to court, they feel very strongly they should have won, they lost, and they therefore complain that the judge was incompetent, made up their mind ahead of time, didn't really listen to their evidence, etc., etc. We do investigate all those. But if it simply looks like the person disagreed passionately with what the judge did, that's not a code violation, that's an appealable issue. So the confidentiality partly exists to protect judges' reputations from unsubstantiated or flat out wrong complaints being unduly publicized. Take the Public Disclosure Commission. They have a different charge, so they don't have equivalent confidentiality requirements. And you'll notice that right before election time, a bunch of little stories will pop up in the media, complaint filed against so-and-so or so-and-so, often by their opponent, as absolutely a desire to make it look like the person that they're complaining of did something wrong, whether it's true or not. This confidentiality in pending or dismissed complaints is designed to insulate against that, because what we ask judges to do in our culture is to make hard decisions between people who are irreconcilably at odds. Somebody's going to win, somebody's going to lose. And so the confidentiality in part protects judges from unduly having their reputations harmed, and the justice system with unsubstantiated or just flat out wrong complaints. it also is a means to prevent our process from being abused as a way of harassing a judge by the bar, for example. Again, they have a different charge, but bar discipline practice is that everyone who is complained of gets notified of that complaint. And even if you know you didn't do anything wrong and it's eventually dismissed, it's pretty distracting, it's unpleasant. And so this process is not supposed to interfere with the judge's core work. Now, we're very open in other ways. By constitutional amendment, originally, when this commission was created in 1980, there was the option of private sanction, non-public sanctions. And that was changed in the mid-'80s by constitutional amendment, and we no longer have non-public sanctions. Many other states do. So California, quite a number of other states, have the possibility that a judge can be found by the commission to have violated the code, charged privately, proven to have violated the code privately, and that sanction never gets made public. Washington does not have that option. So if the investigation goes on to the point where the commission has its own independent evidence that the code was violated and they bring a charge, that must be public. If we have an agreement with the judge and they stipulate that the code was violated and there should be a sanction, that must be public. We have no non-public sanctions.
Okay. And the commission goes just straight from the code, right? Of the
I don't know what
the
you're
canons
asking.
and the code. That's what they enforce, and nothing beyond that. Pretty much.
Well, it's a little oversimplified. If a judge commits a criminal offense, the fact that they've committed a criminal offense is a violation of the code. So there's interplay with other regulations and statutes and stuff.
All right, and are there ever spot checks? Does the commission ever do spot checks, or do they just work on complaint?
Spot checks.
I just go into a court and make sure that the judges are doing their...
No, we don't really have the time to do that. Although, again, unlike some other states, the commission is empowered to investigate of its own initiative and doesn't have to wait for a complaint. Typically, that might happen, I just said, if a judge violates the criminal law. If we read a media article that a judge has violated the law, the criminal law, then you can pretty much bet the commission will start its own proceeding. Similarly, if we're investigating something due to a complaint and we notice, oh, it also looks like the judge violated the code with X, Y, and Z, we don't have to wait for a complaint to investigate X, Y, and Z. We can pursue that.
Okay. I just have one more question. Now, it's been alleged that by some that the commission is not an organization set up to maintain and discourage bad faith acts of judges and to promote confidence in the judiciary, but rather an organization which provides an extra layer of cover for judges acting in bad faith, and that the record of disciplinary action taken versus the amount of complaints lodged is clear evidence of this allegation. And you sort of went into that a little bit, but how would you respond to that?
Well, we have a free country and people can think what they want to think. So I wouldn't say that people can't hold a given point of view. That is not correct. We take every complaint quite seriously and have taken complaints that looked pretty nutty, went ahead and investigated them. Oh gosh, that really happened. There was a Gig Harbor judge who's no longer a judge. He resigned because of the case, and the allegation was he had a secret code so that the audio would be turned off while he was acting out, and then he had another secret code so the audio would be turned back on, which sounds pretty paranoid, doesn't it? So we looked at it and, oh gosh, he did do that. So we pursued that, and my point is that we spend a lot of time investigating allegations, even if they appear on the surface to be filed by someone who may be unstable, by somebody who has an agenda. Almost everybody, in fact, does have an agenda, and it's our job to parse that out fairly find what the facts are and see, is that in fact a violation of the code. We have sanctioned sitting members of the commission, which is very uncomfortable. But we've done it. We have sanctioned sitting state Supreme Court justices who did not take kindly with that challenge to their power and did their utmost to attack back the commission and its individual employees for doing that, which was very uncomfortable. But that's our job. And, some people just really, really suspect the government and are inclined not to trust it. I see that. I am very personally confident, and I've been working here a long time, that this agency is one that believes in and strives mightily to fulfill its charge of maintaining integrity and independence, and I think we do a good job. We certainly try to.
Excellent. Thank you. It seems like the judges must be very much, they must be very excellent, because there's less than 1% of them, at least last year, that had any sort of disciplinary action taken against them.
Those percentages are consistent across the country. That not the less than 1% deal, but I think it's more hovers around 95. If we are talking about numbers of complaints received that result in action, those are typical, and I believe they're typical because of the phenomenon that I explained to you. A lot of complaints come from people who lost in court and think, oh, there must be something wrong with that judge. And perfectly natural and understandable, but that's not a code violation. Even if the judge got the facts in the law wrong, unless they did so with a bad intent, i.e. said, I am now not going to follow the law, or I am now going to find facts that I know are not supported by the evidence, that would be a code violation. It'd be tricky to prove, but that would be a code violation. But if they plain old flat got it wrong, and terrible harm ensued, including someone's deprived of their freedom, someone is deprived of custody of their child, and the person who gains custody is harmful to that child. I mean, terrible consequences can come because the stuff that goes to court is important. That's not a code violation. So, but it'll probably draw a complaint. The fact that that complaint got dismissed doesn't mean that the agency is covering up for the judge. It means the agency's charge is to enforce the code, and there wasn't a code violation there. Maybe a pretty bad judge. Maybe that judge should be replaced. Maybe the electorate should unelect them next time they come up. But it's not a code violation.
So if the judicial, or if the commission finds that there is no violation, is that basically the end of it? Can a person still go on to the Supreme Court or take it to another venue, or is it pretty much done there?
I want to make sure I'm understanding your question. If the person thinks there was a code violation and the commission dismisses it, does the complainant have redress further?
Yes.
No, they don't. It's an independent agency, the judicial branch, and the way it's designed is the complaints are final, the dismissal complaints are final with the commission. The complainant can come back with new or different information and ask that their complaint be reopened. And if that is done, then it'll be assigned to a different investigator than who did the first one. They'll still be privy to all the original information from the first complaint, but they'll reanalyze it and reinvestigate it with whatever the new information is and present it again to the commission as a reopen request.
So even if a person's rights are violated, as long as the judge does not violate the code willfully or knowingly or says that
or
they
incompetently,
don't know, then they're in the clear, basically. They're not going to be brought to justice. There's no redress for that individual whose rights were violated.
I don't agree with that. If they didn't violate the code, there's nothing more this commission can do. But there are. Can I finish?
Yes.
There are other avenues. So, for example, if it is a terrible violation of rights, then the person could pursue that through the appellate process, which I know is very expensive and hard to do, but that's one avenue. Another thing they can do is go to the press and publicize what happened, and if they have success and get some footing there, they can publicize that judge was a terrible judge and did a terrible thing. If that is an elected or an appointed judge, then the person who is harmed can run against or recruit someone to run against or support an opponent to that judge, or lobby the judge's appointing entity to say, this is a terrible judge, look what they did, look what they've done to me and other people, do something about this. So there are other avenues in our society, but I'm not going to sit here and pretend the commission can do more than it can do. It's what we do.
Right.
That's our tool chest.
So if a judge is say they're clearly acting outside of an authorized jurisdiction, there's only, say, 2 criminal jurisdictions allowed under the Constitution of the United States. There's one is under admiralty and one is common law. And so if they use say, admiralty or military tribunal instead of the common law where they're allowed, the commission can't do anything about that.
Well, I told you when we set up the interview that I couldn't talk about specific instances or cases.
Right.
So
That was just broad. The jurisdiction.
It's too broad for me to answer.
Okay.
We'd have to look at an individual set of allegations and see what the facts were and stuff like that.
Okay.
So I really can't answer a question like that in the abstract.
Does the board or does the commission look into matters of jurisdiction?
If they're relevant to the code violation, yeah, sure.
Okay. All right. I think that is. I'm sorry.
What's the time lapse? You must get a mass amount of complaints since you're handling the entire state. So what's the time lapse between receipt of a complaint and the start of an investigation on average?
A week or 2.
And are the complainants generally notified of the commission's decision? Whether
Yeah.
Okay.
Typically they are. So if they won't be, sometimes they don't give us any means to contact them. What they don't get is they don't get a report.
Right.
The investigation's not being done for somebody. We don't become their investigator. We're doing what we do for the benefit of the general public and the health of the judiciary at large. And we already talked about confidentiality, so the information people get is unfortunately frustratingly bland. I have occasionally, and others, say somebody has an allegation that the judge said something really awful and insulting and horrible to me, and we accessed the audio or the video, and that's not really what the judge said. The person might have reasonably misunderstood it to be that, but they actually said something else. We probably would, just to make the person feel better, say, listen, we listened and that's what they really said. Because if they had said the terrible thing, we would have gone after them.
All right. Well, I want to thank you very much for your time, viewers.